Peace, 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 peace. Welcome back to the You and I Verse All Temple for the sun, planets, moon, and stars. I'll be your Lord of Hosts, Lord Messiah. And we're going back in to the federal rules of procedure. You know what I mean? More so, rather I say, criminal. We're going into investigation, charging. We're going through the steps of our federal court procedure. You know what I'm saying? So now we're going into charging. Alright, let's see what they got to say about charging. So after the investigation, and these are the steps of the trial. After the investigation, then they come with the charges. You know what I'm saying? They let you know what they're going to charge you with. You know what I'm saying? And that's usually at the arraignment or the initial hearing.
Charging. After the prosecutor studies the information from investigators and the information they gather from talking with the individuals involved, the prosecutor decides whether to present the case to the grand jury. When a person is indicted, they are given formal notice that it is believed that they committed a crime. The indictment contains the basic information that informs the person of the charges against them.
Pause. So, once again, I keep using this Young Thug trial as a reference, and I say y'all should watch that trial and see what's going on with it. Because you learn a lot about court procedure. Like the stuff I'm explaining right here in the breakdown, you can see the visual of it, like the motion of it. You can see this in action, is what I'm saying, when you watch that court trial. So, in the trial, you know, they're charging him, they indicted basically him, you know, all his homies and all of that. So basically they got a lot of charges in the indictment. So what they're trying to do is get him to cop out to things, get him to admit to this and that or whatever, you know, see if he gets probation instead of jail time. I think he already copped out to like 8 years probation or something, already with the time he already served. I think he's been locked up for like 2 years now, something like that, I think already, or going close to like, you know, 2 years or so. Yeah, but I think they because, you know, he is an artist, whatever, so I think they're going to give him like a work release type thing or something, you know what I'm saying, let him do his thing or whatever. But I think he had to admit to the racketeering charge, and I think he's going to get like mad years of probation or something. But once again, that's just for what he admitted to, but he still got to face the other charges from everybody trying to snitch on him, so they don't got to face jail time. So like I said, that's what they're trying to do. They're trying to get all the circumstantial evidence against Young Thug, get all his homies to snitch on him, so they could bring these charges against them in the indictment, make it stick. You know what I'm saying? Because right now it's alleged. You know what I'm saying? Even though it's evidence for them to consider. You know what I'm saying? But it's still alleged until they actually prove it. So you know, like I said, this is the methods that they do to try to make their evidence stick. So this is charging, y'all.
Them. For potential felony charges, a prosecutor will present the evidence to an impartial group of citizens called a grand jury. Witnesses may be called to testify, evidence is shown to the grand jury, and an outline of the case is presented to the grand jury members. The grand jury listens to the prosecutor and witnesses, and then votes in secret on whether they believe that enough evidence exists to charge the person with a crime. A grand jury may decide not to charge an individual based upon the evidence. No indictment would come from the grand jury. All proceedings and statements made before a grand jury are sealed, meaning that only the people in the room have knowledge about who said what about whom. The grand jury is a constitutional requirement for certain types of crimes, meaning it is written in the United States Constitution, so that a group of citizens who do not know the defendant can make an unbiased decision about the evidence before voting to charge an individual with a crime.
Right. So the indictment doesn't come after the jury or after they bring the trial, you know, the court, you know, the case to trial and all of that and expose the information. They make that indictment before, because they have to have enough evidence to be considered to have an indictment. You know what I'm saying?
Crime.
But like I said, remember, they be waiving your 180/80 rights. Like I said, in New York it's called 180/80 rights. Maybe different codes in different states, but they be waiving your rights to the indictment, and basically have you sitting in there, and then after that, after they done waived your rights, they try to get you to cop a plea or something, because they didn't waived your rights. So now they got to get you to cop out to something and plead guilty to something. But dude, you shouldn't have waived my rights in the first place. Maybe they would have dismissed this shit because they didn't have nothing, but you waived those rights just so you could get me to cop out to something. You know what I'm saying? So these legal aids be tricky, y'all. Y'all gotta be on point about that. You know what I mean?
Crime. Grand juries are made up of approximately 16 to 23 members. Their proceedings can only be attended by specific persons. For example, witnesses who are compelled to testify before the grand jury are not allowed to have an attorney present. At least 12 jurors must concur in order to issue an indictment. The federal courthouse in Minneapolis is one of the venues for the District of Minnesota. States are not required to charge by use of a grand jury. Many do, but the Supreme Court has interpreted the Constitution to only require the federal government to use grand juries for all felony crimes. Federal misdemeanor charges do not have to come from the federal grand jury. After the defendant is charged, they can either hire an attorney, or if they are indigent, they may choose to be represented by an attorney provided by the government, a public defender, at no or minimal charge.
Right.
The defendant's attorney is referred to as the defense attorney. The defendant's attorney assists the defendant in understanding the law and facts of the case, and represents the defendant just as the prosecutor will represent the government.
Right, because the government is the federal government. Their federal prosecutors represent the federal government. So the feds, when the feds bring a case against you, their prosecutor is a federal prosecutor. So they represent the federal government. When it's a state prosecutor, the state, they'll be like the state versus so-and-so, you know what I mean, John Doe. It's the state prosecutor bringing the case against you, representing the so-called people of the state, which is actually the property of the state, because the people are the property. We are state property. So let me finish this up, y'all.
Government. Venue. The location where the trial is held is called the venue, and federal cases are tried in a United States District Court.
Right.
There are 94 district courts in the United States, including the District of Columbia and territories. Many states have more than one district court, so the venue will depend on where you live in the state. Within each district, there may be several courthouse locations. Click here to see if you can find the one closest to your neighborhood.
Right. Okay, so we're going to do one more, y'all, before I close this one off, all right? We're going to go into initial hearing / arraignment. So after they do the investigation and bring the charges, when you have your initial arraignment, that's when they're going to inform you of the charges during your initial hearing / arraignment.
Initial hearing / arraignment. Either the same day or the day after a defendant is arrested and charged, they are brought before a magistrate judge for an initial hearing on the case. At that time, the defendant learns more about his rights and the charges against him. Arrangements are made for him to have an attorney, and the judge decides if the defendant will be held in prison or released until the trial.
Right. Now, they said that at that time, the defendant learns more about his rights. Okay. Really, all they let you know is that, well, you have the right to an attorney. If you can't afford one will be provided for you. But remember how I was talking about how, you know, let's say if you plead guilty to something, right? Or you're found guilty to something, right? And they say before they find you guilty, right? They be like, you understand by pleading guilty that you're giving up certain constitutional rights? And I'd be like, yo, see how they said at that time the defendant learns more about his rights? How come they don't tell you about those constitutional rights at that time? This is the initial hearing or the arraignment. Not at the end of the trial when you're about to plead guilty to something and then they saying, oh, by pleading guilty, do you know you're giving up certain constitutional rights? Why do you wait all the way to the end to tell me that? You're supposed to tell me that at the initial hearing or the arraignment, right? They just say at that time the defendant learns more about his rights. By who? Who teaches him these rights? Who does he learn this from? The lawyer that they give him, the public defender? Because they don't teach you nothing about no constitutional rights. They don't tell you. You don't never hear no lawyer, no They'll never tell you nothing about it. You know you have constitutional rights, right? You know you have this right and that right. They don't tell you nothing about that. They just tell you, come to court so I can turn you over to the jurisdiction of the court and get paid. That's all they tell you. They don't tell you no rights. Anyway, let's continue.
Trial. In many cases, the law allows the defendant to be released from prison before a trial if they meet the requirements for bail.
Right.
Before the
Part of stuff, like I was saying before, the criminal thing, when you're sitting in that holding cell and they come in there and they send you that public defender, they're like, oh, I'm on behalf of the public defending department, da-da-da, I'm here to represent you. Then they ask you all those questions like, do you have a job? Are you employed? Do you have kids? Da-da-da-da, what time you got to go to work? Da-da. They try to build up all the information that's good in your behalf to see if you get released and whatnot. And most likely, like, on your own recognizance. Or on a bail or a bond, or do you have any properties? Da-da-da-da. They want to know if you have anything that they could post bond on. Post bail through bond. You know what I'm saying? So they want to know if you own anything.
The judge makes the decision on whether to grant bail. They must hold a hearing to learn facts about the defendant, including how long the defendant has lived in the area,
Right.
if they have family nearby, prior criminal record, and if they have threatened any witnesses in the case.
Right.
The judge also considers the defendant's potential danger to the community.
Right.
If the defendant cannot post bail, pay the money, the judge may order the defendant to be remanded into the custody of the U.S. Marshals pending trial. The defendant will also be asked to plead guilty or not guilty to the charges.
Right. So that's at the initial arraignment or initial hearing or arraignment. That's what they're going to do. They're going to inform you of your so-called rights. They're going to, see if you could post bail or if you meet the requirements to be released on your own recognizance. You know what I'm saying? If the defendant cannot post bail or pay the money, the judge may order the defendant to remain in the custody of the U.S. Marshals pending trial. You know what I'm saying? So they're going to hold you until the trial, basically. If you can't post bail or, you know what I'm saying, or bond out, you're going to have to sit there until the trial, basically. Alright, y'all. So I'm going to end on that one, y'all. I'll see y'all in the next video. What's the next one coming to? The next one is dealing with discovery. We're going to do discovery and plea bargaining. Alright? Peace, y'all. See y'all in the next one.